My name is William S. Harris. I go by Bill, and I have been practicing law here in Tarrant County for 40 years. Well, there's a difference between using self-defense or using a firearm in self-defense in your front yard and inside your home. The statute says that you do not have a duty to retreat if you're in your home. I think it calls it a habitation in the statute. When you're in your front yard, you may be on your property, but you're not in a place, generally speaking, that the public is excluded from. Most of us don't have fenced front yards. And if we did, you could at least make an argument there. I wouldn't want to risk my legal situation on that argument. That's a situation classically where I think you should retreat back into your house, unless that's not practical. If you can, even if you are not in your home and you're in a situation where you may not safely retreat, then you do not have to retreat before you use deadly force. I mean, I don't want to be giving the impression that you're, free target if you're out in your front yard. You're not, but it changes the dynamics. It changes the legal requirements. If you're standing in your house and somebody's trying to come in, then the law abolishes that requirement that you retreat first. Now, one thing you have to bear in mind is that self-defense, I said earlier, you have self-defense and the use of force in defending yourself. That's section 9.31. And that includes anything that is not deadly force. Displaying a firearm is not deadly force. If you hold it away from the person off center and you simply display it that you've got it, that's a use of force under our law. If you point it at the person and fire, that's clearly deadly force. There's some ambiguity about whether or not it's deadly force if you simply point it. The next stage then is section 9.32, which describes those situations in which you can use deadly force. And it starts by saying you first have to be entitled to use force at all under section 9.31, the part that authorizes the use of force to defend yourself or a third party. So you have to first meet that criteria, and then you come to the criteria when you can step it up and use deadly force. And I think that the gun owner should remember that when he is merely displaying that he is armed in hopes that this will be sufficient to deter any further aggression, that's a use of force, not deadly force. So that's an important distinction. There are a whole lot of qualifications about when you may do these things contained in the statute. And we literally could spend 3 or 4 days of a law school course talking about those. This is actually a very complex area of the law. And that's why I say that gun owners need to read that statute. Not because I think that when a situation arises, they're going to be able to suddenly go through their mind and check off all the things, because if you wait and do that, then whatever the situation is will have resolved itself without you using your firearm. On the other hand, if you are aware of what the criteria of the law is and you've thought about it beforehand, then at least you are more likely to stay out of a situation in which you're creating a possibility that self-defense won't apply to your actions.